Good morning, everybody, and welcome to today's risk reduction, risk management class, which is the second class that we did this month. The first class earlier this month was the part one of new and revised forms with a focus on the realtor acknowledgement and disclosure, the so-called RAD, and the referral fee agreement and transparency in the disclosure of compensation. We also touched on the MLSA and talked about the new law that affects LA and parts of Ventura, which prohibits a individual from making an unsolicited offer to purchase property from an owner. And that's zip code wide. It's not just property that's been damaged by the fire. It's the properties in the zip code. So that form, the unsolicited offer attestation form, lists the zip codes where that is in effect for those of you, especially in the Irvine office, that might be working a little bit to the north. Uh, so be aware of that. Call me if you have any questions. This month, we're going to talk about 10 forms, and they're all revisions. None of them are new forms. And we're going to get into a little bit of how to use the forms effectively, go through this, and hopefully by the end of the class, you'll have a good understanding of a few nuances. Some of these forms have been altered because of recent changes in the civil code. So let's jump right into the class. Let me share my screen first, if I can. Think that does it. Everybody see my screen now?
It's loading.
Okay,
Yep, now we can.
very good. All right, I'll open up all right, here we go. So again, how to reach me, everybody knows that's my direct landline on my desk. Email, I keep my email open, so don't hesitate to email me. I'll see that. And also, whoops, also weekends and evenings, call my cell. You can call it or text it, either one. And I'm happy to take your calls. Most of you have heard one of my mantras. I have a few of them, but one of them is if you're working, I think I should at least be available. So have no problem with you calling me on evenings and weekends. That's for a lot of you when you're closing, you're doing your business, getting ready to, write offers, show property, go on listing appointments. Just because it's a weekend, you're working, at least I'm available. So don't hesitate to reach out to me at any time. All right, so a few more new and revised forms. These are from the December 25 forms release. So these forms are currently in use now with these revisions. Some of you probably already uncovered the changes, and for the rest of you, you'll get a good overview of the significant changes. But when we get through this class today, we'll have questions at the end, of course. So the first thing I want to talk about is a few modifications that have been made to the RPA. Nothing really extreme, but just a few little things. So let's go through them. First thing on page 2, looking at possession. There, in the way the form was structured before, it was easy for a seller to get in trouble selling a property that was tenant occupied, and a tenant is legally defined as anybody, any adult living in the property who is not on title. So if you own the home by yourself and you're living with somebody and they're not on title, they're not your tenant, you have a special relationship, but by law, they're called a tenant. So anybody not on title is a tenant, and they have specific rights. And one of them is the right to possession once they've been granted possession. Sometimes tenancy by consent is a term that's used. Somebody is allowed to live in your house. They're not a tenant, but they're living with you. This has come up more than a couple of times, believe it or not, over the last few years with live-in boyfriends or girlfriends. they are legally tenants. They're tenants by consent, and they have the same rights as somebody on a lease or on a month-to-month. So well, the way the form was structured before, it was very easy to get in trouble by agreeing to sell a property to a buyer and give possession to the buyer at close of escrow, but you got somebody living in the house who, for one reason or another, doesn't get out on time. And they have rights. You just can't lock them out. And so you end up being subject to damages by the buyer because the buyer was going to take possession at close of escrow, and you're sort of stuck with somebody still in the property, you being the seller, still stuck with somebody in the property, can't get them out, and now you got a problem. So that was cleaned up a little bit. I'll go through it a little bit. It's still a few things you got to be careful of, and that's, this section right now may be worth the time you're going to put in attending this class today. Because if it never happened to you, then who cares? But if it does happen to you, it can be extremely serious. Thousands and thousands of dollars in damages because you can't get somebody out and you made a commitment to a buyer, your seller has made a commitment to a buyer that they can't honor immediately, like immediate possession. So the first thing to take a look at is for seller occupied or vacant units, of course, uh, the possession is at close of escrow is the default, or you can check one of those boxes, 29 days or fewer, 30 days or more. The reason there's a breakdown is if it's 29 days or less, there's some presumption that it's not a month-to-month tenancy. And so some of the rights that a tenant has, uh, they accrue to the tenant only after being in possession of the property for 30 days. So if you give possession to a buyer, I mean, you allow a seller, excuse me, let me back up. If you allow a seller to stay in the property for 29 days or less, there are certain rights they may not have. So that's the SIP is used for 29 days or fewer. There's no law that mandates using an SIP. It's just an SIP is designed not to avoid any reference to tenancy. So, for example, if there's money being kept in escrow or the buyer is given some money uh, to hold as a so-called deposit, security deposit, if you will, in an SIP, that's not called a deposit. That's a possession fee. Because what CAR is trying to do is to help buyers and sellers not inadvertently end up into a tenant-landlord relationship simply because the buyer is letting the seller stay in the property for a week. So the SIP would be what you would use for 29 days or fewer. 30 days or more, you use a residential lease after sale, an RLAS. And that is, SIP, if most of you know, I think it's 2 pages is all. An RLAS is either 6 or 7 pages because there's a lot of legal requirements that if you're staying in the property 30 days or more that need to be addressed. Okay, so that's pretty straightforward. Now, what about units that are occupied by tenants or anyone other than the seller? Well, one of the things they did is they stated that, that the possession is subject to tenant rights. And so that somewhat notifies the buyer that their right to take possession of the property is subject to the rights the tenant has. So that helps to ameliorate the damages that the seller would be held accountable for. That phrase alone is very helpful. Now, unless if the purchase agreement includes a statement that it's going to be the primary residence or the secondary residence of the buyer, now that got to be memorialized, and that's in E3. You can check either secondary, which second home, or if it's an investment, then that would clearly be not apply in this case. All right. Now, if in fact the uh, there is a tenant in the property, again, that's anybody other than the owner, the person on title, the people on title, then the purchase agreement should include a TOPA, or at the very least, the buyer may not know that. Buyer may not know the relationships and of the people that are living in the property. So they wouldn't probably include a TOPA, but you would certainly, as a listing agent, counter the TOPA back. And so if the buyer intends to occupy the primary or secondary residence, the unit shall be vacant at time of possession. That's the agreement. But the TOPA, you can still have the buyer getting possession at close of escrow, even though it's tenant occupied and you're using a TOPA. And if the tenant does not move out, the TOPA uh, limits the damages the buyer may claim to simply their direct expense of purchasing the property, which is only includes inspections and appraisals, any money they paid for inspections or appraisals. So that TOPA is extremely important. So that's if you know it's a tenant occupied and you're writing the offer, go ahead and include it. If you check this box here, the tenant occupied property addendum, it'll automatically print out with your offer. If you have a listing and the buyer writes an offer, you have a tenant in there or a non-owner resident tenant, if you will, then you would counter with the TOPA. All right, hope that's pretty straightforward. Call me if you have any questions. The summary is make sure you include a TOPA in your transactions when somebody's living in the house, an adult living in the house who is not on title. All right, now page 8 of the RPA has two changes. The first one is paragraph 11A. And what 11A memorializes, and I'm going to talk about it a couple of times, is it allows for an SPQ to be used in lieu of an ESD. So if it's 1 to 4 residential units and a TDS is required, the contract states that an SPQ will also be included. An SPQ contains questions that some of the questions are statutory, which means they have to be answered, and the buyer has 5 days after receipt of those answers to cancel, regardless of whether or not they've removed contingencies or not. So that's sort of part of the TDS, the SPQ. Now, if the TDS is exempt, then you would use an ESD instead of an SPQ, or, and that's the change, or a property questionnaire could still be used. Property questionnaire has the same statutory disclosures that the ESD has. And so that they Carr realized, and I've been recommending it for a long time, an exempt seller can still use an SPQ, especially if they have some knowledge about the property. So my parents had their house. This is not me personally, but my example. Someone's parents uh, have the home in a trust, and they're getting elderly, and the son and the daughter are helping mom and dad frequently maintain the house. They're involved in lots of things going on with the house. And then mom and dad pass away. The son and the daughter haven't lived in the house in years. So they would be exempt from a TDS as a successor trustee, but they know a lot about the property. So SPQ is much more protective of the seller than an ESD because nobody is exempt from disclosing what they know about the property that might affect the value or the use of the property, the enjoyment the buyer might get from buying the property. You have to disclose that. Those are so-called material facts. No seller is exempt from disclosing known material facts. So the SPQ sort of prompts some of the things that an exempt seller might know, but not really realize, oh, yeah, I should probably tell them this. Oh, yeah, you definitely should. An ESD wouldn't prompt those answers. So I hope that's kind of clear. So in a couple of places today, I'll mention the SPQ has been referenced now as something you might use in lieu of or in addition to. You don't really need to do it in addition to, in lieu of an ESD when you are not providing a TDS anyway. Okay. So this is provided during the seller disclosure, provision of documents time frame in 3N1. And unless exempt from a TVS, the seller would complete an SBQ, or it can produce, if they're exempt, an ESD or an SPQ. So just what I just said, I went through it without flipping through my presentation. I got ahead of myself. Okay, now paragraph 4 is not really a change, but I wanted to point that out to you because I get this all the time. Sellers make the disclosures based on their awareness. And the presumption is they're doing it in good faith. But they may not disclose something that is pretty obvious or they're not aware of it. They didn't answer the question quite correctly because they weren't aware of it. Or an inspection revealed something that the seller wasn't aware of. You do not revise disclosures, you being the listing agent, the seller, based upon information discovered subsequent to uh, the creation of the TDS. In other words, information discovered as a result of a buyer inspection or sellers never looked at his title report before. He has no clue really, but he does have CC&Rs. He doesn't realize it, but he doesn't think he does. So in the TDS, no, is it properly subject to CCRs? No. Well, yes, it is, but he doesn't know that. Well, then when the title report comes out, I've had buyer's agents say, oh, no, they got to redo their TDS. It's wrong. No, there's no such thing as a wrong TDS. TDS, I mean, it could be. I mean, the seller could not disclose something they are aware of, so that would be wrong, of course. But it's not wrong if they didn't know it. That's the key. You don't revise it just because you've discovered something later. So that's the point of paragraph 4. I thought I'd point that out to everyone. All right. Now, a new civil code states that the sellers of real property must disclose to a buyer an advisory that the buyer might want to have the electrical system in the property inspected. The purpose for that law, the reason that law was passed, is a lot of homes that were built more than 20 years ago, their electrical system may not support some of the things that today people are beginning to turn to. Electrification is what it's called. Our society is becoming electrified. Our residences are becoming far more demand. The electrical demand on the electrical system has increased. People are installing solar systems, and some of the older electrical systems won't support the solar systems. People are buying electric cars, and some of the electrical systems, the panels don't have enough amperage in them to allow for you to effectively charge your electric cars. You have to, increase your panel size, things like that. So what the legislature passed a law saying that the sellers must simply advise the buyer that they might want to have the electrical system of the house inspected. That's all that is. So Carr put it in the RPA to make it real simple. It's sort of like there was a law passed a few years ago that sellers had to advise buyers that they should check to see if there are any underground gas lines under the property or near the property. Well, so that's a new advisory. Well, Carr got smart, of course, and just put it in the RPA. And so it's in there. Nobody even thinks about it. Same with Megan's Law. That's another one. They just put it in the RPA, these advisories that the legislature has mandated that sellers provide buyers. So that's what 11E is. Okay, I'm sorry, page 15, they moved the liquidated damage, mediation, and arbitration. They consolidated all on one page and moved it to the very end of the purchase agreement. The concept was, let's put anything that needs to be assigned or initialed, that has to be initialed to be effective, to be included in the contract. Let's move it to the back near the signature page so it's all together. So they moved that all back on page 15, both the liquidated damage, the arbitration, and the mediation. They also modified the mediation slightly Car Dispute Resolution Center is the new name for what used to be the Mediation Center. CAR and most of the local associations, I know the San Diego Association does it, I've been there several times, they provide mediation services. Well, now they also provide arbitration services as well, dispute resolution. You can actually do arbitration now through the Association of Realtors. So they put that in. Now, another thing, I get asked this question all the time. This has been there for a while, but I thought I'd point it out. So somebody's uh, buyer's upset with the seller, the seller's upset with the buyer, and they want to take them to small claims court. Well, you got to mediate. No, you don't. Well, yeah, the contract says you have to mediate, otherwise you can't get your court costs. No, you don't. Not necessarily. If the matter in dispute is subject to uh, certain court jurisdictions, it's excluded. So that's what it says. The exclusions of this mediation are specified in paragraph 31B. There's 31B exclusions, and take a look. Any matter is excluded from mediation that is in the jurisdiction of a probate court, a small claims court, or a bankruptcy court, or an unlawful detainer action. Those are exempt from the requirement to mediate and arbitrate. So you have arbitration in your purchase agreement, but the buyer wants to sue the seller in small claims court, they can do that. It's right there in 31B. Okay, page 17, they moved the uh, offer not accepted to the very end of the agreement. The presentation of offer that a listing agent would initial if he's requested to. Code of Ethics requires a listing agent to inform the buyer in writing whether or not the offer has been presented. So that's the presentation of offer. Either the agent or the seller can initial that. Offer not accepted. There's no requirement for the seller to do this, but it's a nice thing to do. Encourage your seller to do it. Think about how your buyers feel when they write an offer and they don't get a response. So encourage the seller to, if they're going to reject the offer, that they initial this. The agent cannot initial, should not initial offer not accepted. Okay. I want to remind everybody, this has been part of the RPA for a while now. It was postponed, this FinCEN reporting requirements. FinCEN, which is the Financial Crimes Enforcement Network, is now going to kick in the next month, March 1. Reporting is now required for March 1. Again, it's being challenged in court. It's being, the people are trying, many people, including large title organizations, are trying to challenge this requirement. And so we may get an update that it's not necessary. But I just checked with escrow this morning. I think escrows starting early in February are going to start collecting this documentation because they cannot close the transaction without having the information they're going to collect. And they need that to do this reporting starting March 1. So you open an escrow here in the early part of February, even if it's going to close in 10 days, heaven forbid. I hate those kinds of offers, but 15, 17 day, 21-day escrow, well, it'll bleed over to a 30-day escrow before you know it, and FinCEN reporting will be required. So this form, pay attention to that. It discusses the obligations to report. Look at March 1 is when now the reporting must occur. And, the parties have to provide the information that the escrow asks of them, and they agree to this. It's an addendum, so they're agreeing to do it. And there are certain buyers and all sellers who are asked, and certain buyers who are required to provide this information, that escrows are required to report when certain buyers are buying the property. And that's basically entity buyers or beneficial owners of entity buyers, signers for entity buyers, trust buyers. It's to identify money laundering. Criminal elements throughout the world have discovered that buying real property is a great way to launder money. I don't want to get too personal and get too far into a story, but when I moved to Canada and bought a new house in a development, Hell's Angels are very big in Canada, and they're a pretty well connected criminal organization up there, and they're out in the open. It's amazing. The local chapter in the town I bought my home in, their Hell's Angels president bought 5 or 6 houses and told me he was just buying them with his drug money to resell them, and it's a good way to launder money. I mean, I mean, it was really out in the open. And so it does happen. People take money that perhaps is ill-gotten, buy a house with it, one way or the other, get away with it, and then they sell the house. Well, it's hard to do now with all this reporting that's necessary, but that's where the FinCEN comes from people who are using money obtained through criminal activity, and it's harder to track once they buy a house and sell a house. So that's the FinCEN situation. All right. Receipt for reports. That's been modified slightly. I want to remind everybody this is a great form and it is something you should be using when appropriate. It's very important. So, first thing, the reports are being provided either to the buyer or to the seller. You check one or the other. And then the reports listed in paragraphs 4 and 5 are specific reports. And then reports aren't verified by the broker or the seller, and then the buyer should do his own investigation. Reports provided to the buyer do not substitute the buyer's obligation to do their investigation. Now, this comes up from time to time when agents, if they are selling their own property or relatives' property, one of the requirements that we have is that a home inspection be gotten. Or if you simply represent a buyer and you recommend to the buyer they should do a home inspection. And in lieu of doing the home inspection, they don't because the previous escrow had one and they just use that one. That does not replace the buyer's investigation. That's a report that is provided to the buyer, an additional disclosure provided to the buyer, but is not a substitute for the buyer's own investigation. So if a buyer buys a home and the home was inspected by the previous in the previous escrow, and that buyer, of course, is given that inspection report, and he chooses not to get an inspection because he thinks that that inspection report he was given is good enough, he would still have to waive his physical inspection. Because you think of it, he's not getting a physical inspection. He's getting the report of a physical inspection. So that's important to keep that in mind. All right. And then there's a list of all the different reports that could typically be provided to a buyer as a part of a transaction. Paragraph 4 is these reports are given to the buyer because this report was specified in the transaction. Paragraph 5 is a list of reports, what I referenced before, where from a previous escrow, they're getting a physical inspection. So we check box A, type in physical inspection prepared by Barry and Associates maybe, or somebody, and then the date of the inspection, and if it's being provided via a link or not. Okay, SPQ. SPQ again, there's some references to the fact that the SPQ can be used even by exempt sellers and is recommended when the exempt seller has knowledge about the property. Some exempt sellers are trustees. They've never seen the property. They don't even live in the same state. You know, they've never seen it, and they didn't have any kind of close relationship with the former owner, the deceased, the original grantor trustee. And now, you know, the grantor trustee, the person who created the trust, passes away, and the successor trustee takes over, doesn't know anything about the property, then ESD is fine. That's good. But the example I cited earlier, you know, especially children who are successor trustees, and maybe they are exempt because they didn't live in the property, but they might know quite a bit about the property. So you should encourage them to execute an SPQ. All right, so this is just details that if the seller's exempt, then the seller should complete a seller exempt, an ESD, exempt seller disclosure. Now, Before a seller fills out a disclosure, they should review the information in a DIA, Disclosure Information Advisory. It's important, listing agents, that you make sure your seller understands that. The DIA should be the top form, if you will, on a stack. If you're doing attachments, that should be the first attachment. And encourage your seller to review that DIA carefully before filling out the disclosures. Many, many claims have been lost because the seller inadvertently didn't do as good a job on his disclosures as he thought, that he did. For example, a real common one is he's had some problems with a feature of the property, so he had it repaired. Maybe he had it repaired twice, but now it's pretty sure it works. Doesn't disclose it. Anything about the repairs. Why? Because it works just fine. That's what he's thinking. No ill intent. No, but that's not good, wise practice, because 3 months later the problem's going to rematerialize, and the buyer's not going to have a problem, and the inspection or the repair company going to say, "Oh yeah, we've been there 3 times. This is really a pain. This thing you've got here." This has happened, folks. And the buyer says, "Wait a minute, they never told me they made these repairs." And then the seller says, "Well, I didn't disclose it because it worked. I repaired it. I got to disclose every single thing I ever repaired." The short answer is yes. And so the DIA does a good job of explaining that to the seller. And absent the seller understanding this, before the DIA was created, I was always concerned that listing agents were not adequately advising their seller prior to the seller filling out disclosures. This was not a good practice in the past. Here's a TDS, fill that out. Wow, that's not too good. Well, if you provide a DIA first and you said, "Here's a TDS, but first take a look at this DIA, read it, make sure you understand it, then fill out the TDS," now you're doing a good job. That's much better. So this is the SPQ, Seller Property Questionnaire. They start out by saying, "Please review a DIA before you fill out this form." Now, it's important also, a TDS can be used uh, for and it can be an SPQ for that matter too, can be used for multi-unit properties. If you have more than one unit, it's a good idea to do specific SPQs, and for that matter, maybe even TDSs. But one TDS for all the units might work. You specify anything that you point out in your TDS as to what unit's affected by that. But an SPQ should for sure be unit specific. So you would check this box which unit the SPQ applies to. Now there's a note to the seller of what the purpose of the SPQ is, a note to the buyer what the purpose is, and then a seller awareness. This is another thing. Buyer's agent, you should point out to a buyer that the seller is not telling you the condition of the property. They're telling you that their awareness of the condition of the property. So just because, I mean, this roof looks kind of old, but just because they state that there's no problem with the roof doesn't mean there's no problem with the roof. It means they're not aware of any problem with the roof. And so you might still want to have that roof inspected. This is a real common misunderstanding of buyers. And it starts, I think, with many buyer's agents not adequately explaining to the buyer that the seller is not disclosing the condition of the house. I've heard that so many times by buyers. The seller told me the roof was fine. No, he didn't. Yeah, he did. You know, it's right here. There's nothing wrong with the roof. No, no, no. He says he's not aware of anything wrong with the roof. So this is a good thing to point out to your buyers. All right. Now, is a yes answer is appropriate is another thing that sellers sometimes goof up on. It's been a long time since they had a problem, so they don't think about it. So you should answer yes if you've ever had a problem. Doesn't matter when it happened. That's a good point. Now, documents. This is another issue, and the SPQ states to the seller, are you aware of any of the following items? And it's all these different things. Are you aware of the existence of these reports, these disclosures, these warranties? Even if they're not in your possession, whether or not they're in the seller's possession or not, is check yes if you're aware of it, and then explain anything in your possession you would provide. Any documents in your possession, of course, provide. Statutory or contractually required or related. These are the questions. These are the questions that also appear in the ESD. Now, an addition to the SBQ was made to comply with a new civil code that states that sellers have to disclose if they're aware of any restrictions to the use or replacement of gas-powered appliances. So some communities have outlawed replacing your gas stove with a new gas stove. You have to get an electric stove. I'm not aware of any in our area, but some do in the state of California prohibit the replacement of gas stoves. Any new construction can't even build with a gas stove. So it states here, are you aware of any possible restrictions in your area? So again, it's an awareness question. Seller, are you aware? And then additionally, another civil code recently passed. In fact, it's last year went into effect January 1 of this year is now there's tertiary smoke. So primary smoke is the smoke that a smoker, the smoke, the smoker is smoking, and that's primary smoke. Secondary smoke is the smoke that the smoker emits in the room that other people breathe in. That's their secondary smoke. Tertiary smoke is smoke residue. Something left over in the house because somebody did smoke in the house. So now that must be disclosed if the seller is aware of any smoke residue, which, if you think about it, you walk into a house and somebody smoked and you can smell it. Well, they're not smoking now. There's no smoke in the house now. They haven't smoked in the house for a year, but you can still smell it. Well, that you're smelling smoke residue. You're smelling what was deposited on the walls and the carpet. And term is off gassing. It's releasing particles into the air, and your noses are very, very sensitive. So, are you aware of any residue from smoking? Then you have to disclose that. So that's been added to the SBQ. Now, this is the DIA that I mentioned. And bottom of page 2, talk about the seller's property questionnaire, and they talk about you can use the SPQ or in lieu of an ESD for exempt sellers. And then exempt sellers ESD is what you must use. And again, you can use an ESD or an SPQ. So Carr is trying to encourage, I've been doing this a long time, encouraging sellers who have a little bit of knowledge about the property to go ahead and fill out an SBQ anyway, even though they might be exempt. They're not exempt from doing the form. You're not exempt from disclosing what you know. That's the point that I wanted to make before, and I'm repeating it now. All right, solar has been modified, and that's an ever-evolving form as we get more and more uh, comfortable with, and the different solar systems are becoming more and more a part of our real estate landscape. And so they modified this form a little bit, and I want to just run through it real quickly with you. It's a three-part form. It's actually two parts, but 3 parts maybe. Okay. So page 1 and the top of page 2 is an advisory. So paragraphs 1 through 5, page 1 and the top of page 2 is an advisory. The middle of page 2 is instructions on how to fill out the questionnaire. So I kind of lump that in with the questionnaire. So I often say it's a 2-part form, an advisory and a questionnaire, but they do have a unique part, and that is instructions to fill out the questionnaire. And then the bottom of page 2 and all of page 3 is the questionnaire. So now the questionnaire, it starts out, of course, number 1 is discusses ownership. What kind of ownership of the solar system? What's the ownership circumstances of the solar system on the house? The phrase I often use is how did it get there? It didn't grow there. It's not like a tree, eucalyptus. I got eucalyptus growing up in my garden all the time. Why? Because the seeds blow in. Next thing you know, they germinate, and a month later, you got a little tiny eucalyptus tree coming up. So, well, that's not how solar system gets there. Somebody did something to get it there. And so somebody owns that system. What's the ownership? And then what documents do you have regarding the solar system? Now, this is for any solar system. Ownership type and documents, and then general questions based upon the solar system for any solar system. Now, paragraph 4 is for solar systems that are owned and convey with the property. Here's a little rule of thumb. I tell agents this all the time. Keep this in mind. Sellers have no clue, their ownership, if you will, of their solar system. Oh, yeah, I own the system. Then we look in the title. No, it's leased. I leased the system. No, you don't. You're paying a power production contract. Sellers don't understand that, and I don't blame them because the solar companies aren't as good as they should be about really clearly explaining to the seller everything that is involved in this purchase of this solar system that the salesman is selling to them. And they don't realize they don't own it, it's leased. I've actually had people tell me they thought it was leased, and no, they borrowed money to buy it. Now, what's the importance of that? If you borrow money to buy a solar system and you have a loan on your house, a second on your house, that will be paid off. Oh, no, 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 the buyer is going to assume my payments. No, he's not, unless you specifically said that. But, we're going to assume the lease. It's not a lease. And I've had that happen more than once. Sellers don't understand that. So one of the things you do if you are representing a seller and there's a solar system on the house is you go through that title report. You should do that anyway. Click every link and look at everything related to solar. And if you don't know what you're looking at, send it to me. I'll look at it with you. But in a minute or two, you will know exactly the ownership situation of that solar system. So if the solar system is owned, then they would fill out 4. If the solar system is either leased or is a power purchase agreement, they would fill out 5. Now, interestingly enough, this is really rare, but once in a while, a solar company sells the panels to the owner, and in conjunction with that sale, the owner agrees to pay for power, which is sort of weird. It's part of the maintenance agreement, if you will. We're going to sell it to you. We're going to allow you to sell it, but you're going to agree to pay for the power while you're paying it off. So it could be that 5 and 4 apply at the same time if it's a power purchase agreement. That is extremely unusual. So it's either 4 or 5 as a rule. Okay, septic inspection, well inspection, property monument, propane tank allocation of cost addendum. That's a mouthful. I call it the SWIPy, and I got that from a Fallbrook agent. He told me years ago, he had a question about the SWIPy. I didn't know what he's talking about. It's this form here. Okay, so there's been a modification. Well, there's a couple of things I want to point out in the SWIPy, and that is that this is the modification. They pointed out, and this is one of those things where, okay, I understand the intent, but it still might be a little problematic. As a rule, listing agents familiar with septic systems wait until the transaction is moving along pretty well. The buyer's gotten their loan pretty much approved before they do the septic inspection if the seller's agreed to the septic inspection. Why? Because the septic inspections have a short shelf life. So you do a septic inspection, within a day or two of opening escrow, and then that escrow cancels and it takes you 3 months to resell it, that septic inspection will probably not be any good. And so agents often with septic, not so much necessarily with termite. Termite inspections have a longer shelf life, but septic inspections, not so much. Well, Carr points out that the contract requires all of the inspections and reports that the seller is supposed to do have to be done according to paragraph 3 and 1, which is uh, usually 7 days after acceptance. By the way, if you're going to agree to a 15-day escrow, then turn the 7 into 3. Give your buyer more than a week to review disclosures and get inspections. Uh, so, so this 7 days is with a typical 30-day escrow. The buyer has 17 days in the boilerplate. So the presumption is, all right, it takes you 7 days to get the stuff from the buyer, from the seller. Now you got 10 more days to review it and do your inspections. With a 10-day escrow and you don't change 7, 10-day escrow is very, very problematic, by the way. But anyway, that gives you 3 days. That doesn't give you much time. Okay, so they're supposed to deliver these inspections within that 1 week period of time. That's what the SWIPY says. So keep that in mind uh, when you're ordering your inspections. And then, of course, any repairs have to be done prior to the final verification of condition. Now, the buyer is paying for the inspection, and they have to act in good faith and get it done early, and that encourage the buyers to do this soon, because if there is a problem, you want to have time to address it. Now, certification. Either the buyer or the seller is going to pay to have the property certified. Be careful in Riverside with certification. With San Diego and Orange County, certification is typically just an inspection. Certification in Riverside includes certifying the leach field, and it can be very costly. So be very careful of that if you're selling property in Riverside and you have the seller. In order for the certification to be obtained, if there are costs to repair the septic system, then the buyer and the seller agree that they will negotiate who's going to pay for those costs. So that gives a seller a level of comfort to agree to provide a septic report and to certify that it works, even though they don't know for sure it works. There have been situations where it can take $25,000, $30,000 to repair the septic system. It's sort of like in the old days when we had I think it was called the WPA, the wood destroying pest addendum. It allowed for a seller to agree to provide a termite clearance with the offer. And that was very risky. And it happened in the old days several times. When they got the termite inspection, they found out, oh my gosh, the deck's rotted, the patio covers rotted, there's rot in the garage, $20,000 termite. Well, I wasn't planning on spending $20,000, the seller says. Well, I'm too bad you agreed to give them a clear termite. So that's why Carr took it out. The WPA went away and they took out the pre-agreement to termite clearance. You could do that if you, as a listing agent, had the property inspected by a termite company prior to that agreement, so you knew exactly what the seller would have to spend to get that clearance. Well, with septic, again, they're not cheap inspections, can be up to $1,000. You don't know what you got. It's not likely, not reasonable for you to get a septic inspection when you put the home on the market. If it doesn't sell right away, it's going to sit there for a while. So they put this in there to say, okay, we'll agree to make repairs, but only if it doesn't cost me any money. So any costs associated with providing that certification the septic system works has to be renegotiated. All right. Now, the buyer counteroffer, the seller counteroffer, and the seller multiple counteroffer. I'll go through these fairly quickly if I can. I think we'll make it on time still. This question comes up all the time, and Carr has now made it easier to do. So offers expire, counteroffers expire. The buyer or the seller accept the counteroffer, or the buyer accepts the offer after expiration. How do we do that? Do we got to start over again? Because you really can't accept it after expiration. Well, you could, but you'd had to go through, you had to write something and have the seller re-sign the form and say, I accept the buyer's acceptance because the buyer didn't accept it on time, or the buyer accepts the seller's acceptance but the seller didn't accept it on time. Uh, so that got to be a little bit of a headache. So Carr very wisely modified the form to make it real simple when you have late acceptance. So what does that look like? Okay, so expiration, all of you know, it's the third day uh, after the counter offer is signed, and the signature is in paragraph 3 of the offer. Of the counter offer, I'm sorry, of the counter offer. So the buyer makes the counter offer. And okay, and it signs it here. Okay. Now, the seller can either accept it I'm sorry, the seller makes the counter offer. Let me stay with this. This is a buyer counter offer. All right, which form I'm on. So the buyer makes a counter offer and signs it. Now, the seller can accept the counteroffer. Now, if he accepts the counteroffer, the time frame, then he just signs in paragraph 4. If the seller accepts the counteroffer late, then it goes back to the buyer. So if this date up here is after the expiration of the counteroffer, but he still accepts it, and the buyer's okay with that, then it goes back to the buyer for signature. And then the buyer ratifies the seller's late acceptance, if you will.
Oh,
So that's what the buyer counter. Same thing with the seller counter offer. Expiration 3 days. Seller signs the counter offer. Buyer accepts it. Great. But if that acceptance date in this paragraph 5 is after the expiration of the counter offer, then it goes back to the seller, and the seller ratifies the buyer's late acceptance. Pretty straightforward once they modified this form and you sort of understand what it is. Uh, if the offers are accepted, the counter offers rather accepted on time, then this late acceptance is never executed. It doesn't matter. It's not important. Make sure your client isn't signing the late acceptance prematurely. That can be problematic. And the same with the seller multiple counter offer. So it expires as well. Okay, and the seller makes a counter offer and signs it. Here it is. It's a multiple counter offer. And the buyer accepts it. Now, with a multiple counter offer, there's one little wrinkle. So the buyer accepts it, and if they accept it on time, then the seller either accepts the buyer's acceptance. Now you've got a contract, or the seller went with another offer, but is accepting it as a backup offer, which a seller can do. Now, just because the seller accepts as a backup offer, it doesn't mean you have a backup offer executed, because then the buyer has to go back and accept the seller's offer, if you will, to make that a backup offer. Now, if this all happens late, then the seller does this late after the expiration of the counteroffer, then the buyer can ratify the seller's late acceptance here. All right, wildfire disaster advisory. This is probably a very good idea, this form. It's going to probably, as agents start to use this more and more, it may complicate our ability to defer defensible space. Uh, uh, what's the word I want? The bringing the property up to code rather to defensible space that may affect our ability to defer that to the buyer, because buyers may think about it a little better before they accept that. So you can defer to the buyer the responsibility to get an inspection and bring the compliance, is what I wanted, to bring the property into compliance with defensible space requirements. The wildfire disaster advisory points out to the buyer that if you agree to that and don't bring the property into compliance, there could be consequences. And that's a good thing to point out to a buyer when a seller is saying, no, we're not going to get an inspection. We're not going to bring the property in compliance. We're going to defer that to the buyer, let the buyer do it after close of escrow. So the form, the advisory, this is just an advisory. It's not a contract. It's an advisory. So it talks about wildfire disasters. It discusses certain issues regarding wildfires. It gives buyers tenant advisory. It provides resources. And now paragraph 5, it clarifies exactly what we're talking about here as far as disclosure and compliance to civil code. So California law requires that disclosures be made in certain cases uh, regarding the risk of a structure on the property catching fire. That's fire hardening. Fire hardening is how hard is the structure against fire. Fire hardening, if it's hardened up, it won't catch on fire. If it's not hardened up, it might catch on fire. So for certain properties, ones in high and very high fire zone, it talks about that down here. For certain properties, civil code requires that the seller disclose how susceptible the structure is to catching fire. That's the fire hardening part. And it also requires that an agreement be reached. It does not require the seller to do an inspection and bring the defensible space into compliance. It does not. With a couple of exceptions in the state, none of them in Southern California. Well, Big Bear partly. Big Bear does have a little bit of that, but you sell property in Big Bear, give me a call. So it requires a disclosure and an agreement. And the agreement is the defensible space portion of the FHDS, where the seller will go ahead and have the property inspected and bring it into compliance, or the buyer will have it inspected after close of escrow and bring it into compliance. So that's explained very briefly, and I think quite well right here. All right. Now, it only applies to certain properties. You know, TDS, if it's TDS exempt, no matter where it's at, it doesn't apply. And it's only for properties in a high or very high fire severity zone. All right. Now, where to get information about this? Well, there's another point I want to make here. The seller has an obligation to determine if they are to comply with fire hardening and defensible space requirements. That's that partial part of the FHDS where the property is or is not subject to defensible space ordinances. It's not a "are you aware" question. The seller has to make an affirmative declaration as to whether it is or not. And the good news is all of your sellers can rely on you telling them, because you can rely on me telling you that properties are affected by defensible space ordinances. So they would check is on the FHDS, of course. But I wanted to point out that that's a seller obligation to figure that out. Now, here's the thing I talked about before: post-closing issues. This was added to the to this advisory. So a buyer agrees to bring the property into compliance after close of escrow and doesn't do it. Just, okay, great, bought the house now, whatever. There could be fines and enforcement actions by government agents. I haven't heard of that yet. I don't know that the government is routinely checking on all the properties yet, but they could. Now, they wouldn't fine you until they first checked on the property and gave you notice you have to bring the property into compliance. And again, this is the surrounding area, not the building itself, but the grounds. You know, you got brush, you got dead trees, you got branches overhanging your roof, that sort of thing. You could be having increased insurance premiums or even cancellation of policies because the defensible space is not being maintained. And then finally, if you don't do it, you're going to have to disclose that when you bought the property, you agreed to get the property inspected and bring it into compliance within 1 year, and you haven't done it. And you'd have to disclose that. So this paragraph C here, I think if buyers pay attention to this, they get this advisory, they pay attention to it, it may complicate a seller's ability to defer that inspection and bringing it into compliance requirement uh, to the buyer. You can do that, but an agreement has to be reached. If an agreement can't be reached, then you really can't close escrow, or you shouldn't close escrow. Okay, now also optional disclosures and reports for properties that aren't even in a high or very high fire zone, or even properties that are TDS exempt. A seller might want to disclose that the what they know about the property's susceptibility to fires based upon defensible space and/or fire hardening. And then the final thing, real quickly, uh, and that is HOA form has been modified, HOA RS, the request for required statutory documents and charges. That's been modified to comply with what civil code now states. A lot of people don't use this form. Escrow orders this in general. But now civil code requires on page 2 of that form that a copy of the so-called balcony inspection report be provided to the buyer. That was not a requirement in the law. The condo association required to get the inspection, but they weren't required to provide it to anyone. And that was a problem. So now they have to provide it. Civil code actually said they have to make a copy available to the seller as well, even if the seller's not selling the property. Problem we've had is lenders want to see this sometimes, or buyers want to see it, and the HOA won't give it to anybody. But now civil code requires that that report be provided. Folks, that wraps up today's presentation. I hope I didn't confuse anybody. Well, thank you for being a part of this class. And Lindsay, let me ask, do we have any questions?
Yes, we do have some questions. The first one is if the RLAS is used for over 29 days, does the buyer take on the property manager status, or does the agent who was involved in the transaction take on that role?
Oh, no, that would be the buyer. Yeah, yeah. Unless you agreed to manage the property, you're not, yeah, an RLAS does not confer management responsibilities on the buyer's agent. Yeah, good
If
question.
if a seller's exempt and can do the ESD, but has secondhand information, do they need to disclose that?
Yes. Now, secondhand information, I don't want to get in the weeds here too much. We can talk one-on-one. Secondhand information, uh, you disclose what you know. You know, if you know that you've been told that the neighbor across the street, you know, has rattlesnakes as pets, that's probably something you'd want to disclose, but you don't know that he does. So that would be a hearsay disclosure, and hearsay disclosures are required. So where that comes up commonly is the neighbor tells you about some other neighbor. You're the listing agent. Well, the seller doesn't know anything about it. You don't know anything about this other neighbor, but neighbor A told you something problematic about neighbor B. Well, that's a hearsay disclosure that you would make according to one of the neighbors, another neighbor, XYZ, whatever. So, yeah, so something that you were told, case by case basis. Sometimes you're told things and it doesn't rise to the level of a disclosure, but sometimes it does.
So do you use a certain form to disclose those? What form would you use to disclose it?
Well, you would use, if you're using ESD, I mean, both forms. There's a place where disclosing any material facts, and there's a couple of blanks. And then what you type on the blanks, if you have to write a paragraph or a page, see attached. And then you would create a document, if you will, and attach it to either the ESD or the SPQ. And again, the answer to your question is you would start that disclosure on the material facts, any other material facts to disclose. Then you would say, see attached, yeah, neighbor across the street. Well, you wouldn't identify the neighbor per se, but one neighbor saying something adverse about the other neighbor that might affect the use of the property.
Okay, thanks.
I think this is referring to the part of the SPQ you talked about with the smoke. Does it include fireplaces?
No, no.
So for residue of smoking, what if the tenants from the condo unit below smoke marijuana and it has come up through the vents to your unit?
You would disclose that.
How far does the propane tank need to be away from a home?
Oh, that's a good question. I don't know. I don't know. I'm not sure they can't be right up against the house. I don't know that question. I'm curious. Maybe call me. I'm curious to know why you wanted to know. Just curious or is an issue. I would research that for you, but I don't know.
When you
Regarding propane, by the way, I don't want to get in the weeds here too much, but if you're selling property, frequently they have propane tanks and you're aware of this. But if you're not, propane, once it's put in a tank, is, if not addressed, real property. It's like water in a swimming pool. Or as one attorney told me, think of the water in your toilet tanks. You haven't used it yet, but it conveys, you know. So propane, there is on the on the SWIPY an option for the tank to be measured at just prior to close of escrow, and the buyer to reimburse the seller for any unused propane. Absent doing that, the seller is not going to be able to make a claim that the buyer owes them because that tank was full of propane. And this can be expensive. We had a issue a couple of $1,000. And the propane tank was, according to the seller, inadvertently filled. Well, guess what? Once that propane got into the tank, absent any agreement beforehand, it became part of the property.
I can't remember which form this is referring to, but when you refer to balconies, were you referring to all balconies or just wood balconies?
No, wood balconies. Yeah, it got to be very bit more specific. Yeah, the civil code requirement for inspections is only for balconies supported by wood or wood products that are higher than, I think, 5 feet. So, an elevated deck wouldn't classify this, but if it's elevated up 7 feet, then it would be legally called a balcony. If it's supported by wood, then it has to be inspected. Uh,
When you're disclosing secondhand information, do you identify who told you in the disclosure?
you want to be kind of careful. Again, that on a case-by-case basis, call me and we can talk about it. Uh, because that person's going to deny they ever said it, and now you've made an affirmative statement that you can't prove. So, and these are interesting questions because they do come up, but they're kind of unique, case by case. Got to look at the facts. But neighbors end up fighting with each other and start saying things about other people, and sometimes neighbors want nothing more than to screw up the poor seller and selling the house. That's all they want to do. And now so there's lots of little things to think about. So by all means, don't hesitate. I've been called more than a few times, or things going on in the neighborhood. How do we handle it? What do we disclose? But you
Well,
got to keep in mind, the best question is, do we need to disclose this? I'm sorry, that's a good question, by the way, if you don't know. The best answer is, why wouldn't you? Well,
well,
I don't
if
want to upset the buyer. Well, that's exactly the definition of something you're legally required to disclose.
Walt, if you cannot verify it, why would you want to disclose?
Because the fact that you can't verify it doesn't mean you're exempt from disclosing it.
Huh.
See, uh, but again, it kind of depends on the circumstances. So, see, I've never, I'm trying to think of a quick example off the top of my head, but uh, I'll give you an example. A neighbor is having wild parties, and the the house is vacant. Seller doesn't live there anymore. But a neighbor's having wild parties, and the whole neighborhood hates this neighbor because when he has these wild parties, cars are parking all over the place, and after the party, there's liquor bottles all over the place. Well, you can't verify that, but that would be very disclosable because the buyer buys that house, and then what the heck's going on in this neighborhood? Oh, yeah, wild parties. Didn't your agent tell you? I told your agent. And now the buyer says, I'd never have bought this house if I knew there would be wild parties. That is kind of a true story, by the way. That kind of happened to an agent. He's not with us anymore. He's in Puerto Rico enjoying the beach. But he had a listing. There was more to those parties than I want to share on this call, but it was a very interesting dilemma he was in. But he had to disclose it. And it did make the house kind of hard to sell.
On a different note, Sandy would like to know if you can explain AB 628 that went into effect starting 2026.
Yeah, I
What,
have
what,
a specific question for you, Walt, is I have a particular property that the way it was set up is with the 2 and a 1 bedroom. The 1 bedroom has a separate entrance and has always been rented out as a separate unit other than the 2 bedroom. And the owner has always just had a refrigerator and a sink, but no stove. But I'm just wondering whether he is now supposed to provide a stove, or if the stove has to be a physical stove, or can it be something that's on the counter, like a, like a cooktop, or not even a cooktop, but some of these that you can just plug in. So just a question.
right. I
What
mean,
is
we could
legally, what do I have to give legally?
legally, the owner, a landlord has to provide both a stove and a refrigerator. And the buyer can accept the responsibility of providing that, but it cannot be a condition of the rental. So if you're renting out now if it's a room, you're renting a room, that's different. But if you're renting what sounds to me like you're describing a junior ADU,
Right. So this is a very unique
then
property, is
yeah,
that it was set up as a 3 bedroom condo, but the 1 bedroom has a separate entrance, and most of the units in that particular neighborhood are set up like that.
does it have a separate, wait, does it have a separate heat source?
It does have a separate, no, it does not have a separate heat
Well,
source.
then you call me, but that sounds more like he's renting a room
Okay, all right.
because units have to have a heat source. You can't rent a unit without a heat source. Legally, I mean,
Right, I
can't rob a
understand.
bank legally, but you can rob a bank if you're so
Okay.
inclined.
It's the heat source is with connected to the main house.
Then he's not really renting a unique unit. He's renting a room.
Right.
So there's
Okay.
a slightly different set of parameters there. Call me and we can talk about it specifically.
Okay, sounds good. Thank you.
Yeah, of course.
How would you know if a balcony is supported by wood beams or metal, if it's tiled or covered? Most residential structures are made from wood.
Well, that's a good question in the sense you might want to have an inspector, call a contractor, ask them for their opinion. Uh, One of the ways you can, assume that to be true is how many stories the structure is. But even that's not a guarantee. Uh, so if it's encased in like a stucco wall behind a stucco wall, for example, then I believe it's going to probably be exempt. I think before I get too far on the limb, I might want to get specifics so I can share that with you. But when in doubt, assume it might be an issue and then call me and I'll get the determination on whether or not it's required.
That's it. That was the last question.
Well, great, folks. Thanks for participating. I appreciate all of you giving up your time to keep abreast with all these issues because it's what keeps you out of trouble, the company out of trouble, And you get to keep your money that way. And I like that. So have a great rest of the day, and call if you need anything. Take
Thank
care.
you all.
Bye-bye.
Bye, everybody.
Thank you, Walt.
Bye-bye.